Hello, everybody, and welcome to this edition of Macro Pro and Friends. We've had a little bit of technical difficulties this afternoon getting started, but we will make sure that we stay on time. I would like to introduce my guest, Alan. Alan is a specialist in mediation. How are you doing, Alan?
I'm doing well, thank you.
Alan, I saw him at a conference at the National Self-Insured Conference, and he was speaking at the same conference I was, and I felt that his topic was really important and something that maybe those of us in California may want to hear and learn more about. So he is a guest today. I'm going to do a little bit of housekeeping before I turn it over to Alan. So just a few reminders. Today's event is worth 1 CEU. You will be receiving that via email, and it will be there within an hour after the presentation. Make sure that you download that immediately so that you have a copy of it. We don't produce them, GoToWebinar does, so it's really important that we do it immediately because they'll take it offline, I think, after 2 weeks. You need to be logged on to the GoToWebinar platform, so if you're just calling in, you will not be able to receive a certificate, so you want to make sure that you are online as well. We have handouts for you today, so you can download those under handouts. And then if you have any questions for Alan, go ahead and put them in the question box, and I'll try to get to those at the end of his presentation. And if you really like what you saw, you can always watch us on the Macro Pro YouTube channel. So at this point, Alan, I am going to turn it over to you. Thank you so much, and have a great presentation.
Thank you, Diane.
I was a hydraulic mechanic for about 27 years. I was working one day, was moving some equipment around, and I went to pick up one block of wood. And whenever I did that, that's how I received my injury. That's when workman's comp basically came into the picture. I didn't know what was going on because at the time this first time anything like this ever happened to me. When this happened, I had to learn how to walk again. So I was scared, to be honest. I was nervous.
Hey, this is John Clinton. I'm trying to get some information about when I'm going to be able to see a doctor for my back. I was told by my employer I had to get permission from you to see a doctor. My wife wants to know if I'm going to get a paycheck while I'm off work. My employer doesn't know the answer to this question.
At the time, I was worried about, I had to get back to work. It was pay, just work, family and bed and stuff like that.
Hi, you have reached Kathy in Claims. If you are a provider calling for authorization of medical treatment or to check on payment status of a bill, please press 5 or hang up and dial 1-800-555-5555. If you are calling to report a new claim, please press 3.
It affected the family tremendously. We couldn't reach anything between me and workman's comp. So they said we had to get a mediator. That's when we had to start out. It was like talk to the family.
So I want to share a few thoughts with y'all. Appreciate y'all having me this afternoon. I am located in Louisiana, and what I'm going to share is the experience of mediation as an effective tool in Louisiana. I will suggest to you, I think that it is a tool that you'll find helpful in whatever jurisdiction you find yourself working in because of what mediation is. Mediation is about choice. It's about inviting people to a conversation. And I start with that video about Denny. I want to give you a little background on Denny. Denny works in the oil and gas industry, and I think most of y'all are on the West Coast. Louisiana is primarily a rural state. It's got about 5 or 6 what we would call large cities. They're not very large in comparison to cities in California and other states. But Denny and his wife Jen were high school sweethearts. They grew up together. He worked in the oil and gas industry as well as he did. His family did as well. And Denny was a year ahead of Jen in high school, and Denny was about to do what everybody in his family had done before him, which was drop out of high school and go to work in the oil and gas industry. And Jen came to him and said, look, I care a lot about you, and I think we have a future together, but I have to tell you, I'm not going to marry anybody who does not have a high school diploma. And while that may sound strange to many of us, that was a real challenge for Denny. And so Denny went to a boarding school on the Gulf Coast in Mississippi run by some Jesuit priests, and they were pretty hard on Denny for a year. But a year later, he and Jen walked across the stage together and graduated high school together. They were married, started their family. And then at 39 years of age, he has this unexpected event. And so Denny comes to this process unaware. He didn't ask to be hurt, and yet he's confused, as you can see from his video. And I start with sort of how Denny and most of the people that we work with have been introduced to this resolution process. And if you rewind way back to the 80s, I started practicing in 1986, and that was right at the advent of the personal computer era. The total quality management movement by Tom Peters and different management gurus was beginning to take hold. Large organizations were beginning to implement Six Sigma programs, all of which were focused on efficiency. And efficiency is wonderful, and we've all enjoyed the benefits of technology and efficiency. And I'm not an anti-technology person in any stretch of the imagination, but there's another side to that equation called effectiveness. And I know that if I could see all of y'all in the audience, because I've done this presentation, as Diane said, at the National Council and then several other conferences, every one of us, as much as we enjoy smartphones and PCs and technology and voicemail, we reach that level at some point where it's like, could you please just get a person on the line? I can't press any more options. I can't find my claim number. And that's kind of where Denny was. And fortunately for the employer in this case, they realized that Denny was trying to make sense of a very difficult situation, but was unable to reach anybody in that process. And so that's how Denny ends up in our office. He's unrepresented, which we certainly handle plenty of those. But he comes here with all the anxiety, uncertainty, and fear that any of us would have being thrown into a different situation. So my hope, as I said earlier, in the next few minutes is to share with you some of the experience out of the Louisiana market. I really think that the tools and the concepts are playable across the country, but what's closest to me is what we've done for the last 18 years. So this is how it starts. I'm not one of those people who knew early on, gee, I want to be a lawyer. In fact, I was a residential builder, and I'm going to date myself even further back than 1985. When I got out of high school, what I knew I was going to do was build residential housing in Louisiana. And why did I know that? Is because that's what my dad had done. And I grew up in all of those trades. I framed, I formed, I pulled wire, I plumbed, and I built houses until 1979. And in 1979, some of you may find this hard to believe, but if you'll look it up, thanks to technology, you can do that without having to go to the encyclopedia. The prime rate, the best commercial rate that businesses can borrow money from banks went to 22.5%. And it's just unheard of. I don't think it's ever been that high before or since. But that's living proof, or I am, that you cannot borrow money, run a business, build a house, and support a family. And so I thought, well, you know, I'll go to school. I mean, school's never been a huge challenge. Law school is a little bit different, but that's how I ended up in the legal business. And then I ended up, because the folks that I worked for were insurance defense lawyers, And that's how I ended up handling work-related cases. I did that for 21 years, 7 years in 2 different firms, and then the balance of those years in a small boutique firm, if you will. But I always had in the back of my mind, and I think this comes from working in an industry like home building, was the only question that anybody I built a house for was, when can we move in? And so it occurred to me, you know, in the claims world, the best day is when a claim closes. I mean, we've all heard the cliche, the best claim is a closed claim. So I kept thinking, man, we have this mechanism, this system that we do to manage this process, but how can we get a high return, highly effective, low risk option in this process? Well, in the early 2000s, I had been practicing for about 21 years, and somebody called me one day and said, Alan, John and Susie and I have this case, and we'd like you to sit down with us and see if you could help us resolve it. Well, if any of you are lawyers or have practiced law or been familiar with that, that's kind of a panic moment, because immediately I thought, oh my gosh, I'm in a case that I haven't responded, I've missed a deadline or something. And so I asked him, I said, am I in this case? No, you're not in the case. We just know you understand a lot about this type of law. We want you to sit down with us. So I said, okay. So I did, and we were able to help resolve the case. About 10 days later, somebody else called me and said, hey, I heard you helped John and Susie. Could you help us? Well, I wasn't at the top of my law school class, but it didn't take me long to figure out, you know, this might be that highly effective, low risk method of trying to help bring resolution to these cases that are difficult to close. And so around that time, I started mediating, and then slowly over the next 2 to 3 years, I just migrated out of law. And today, it looks like myself and 3 mediators, and we stay busy most every day, because mediation, as I said earlier, becomes an option for choice. And you invite the Denny's, even if they're represented, into an environment where people can truly ask questions and explore options in an unfamiliar scenario like a workers' comp case. And so just by the numbers, roughly, this is kind of what it looks like over 18 years. I mean, we were fortunate enough, and still are, to have many folks trust us to help them bring their cases to resolution. About 6,000 mediations, and when I sit with somebody new, I say, look, it's not that I have the answer to your case. Every case has its own answer, and it comes from your understanding of how the system works and what choices we can offer today that give you a better tomorrow. This is your case and it's your tomorrow. And when I tell them that I've mediated close to 4,000 cases, I assure them that every case is different, but I've sat in front of a lot of people, and really we are all more alike than different. We want control of our life. We want tomorrow to be ours. We want the bumps to be smooth and the hills to be lowered. And a workers' comp case, at least in my experience, has always been full of bumps and hills for most people. And this is the part that really, I think, works wherever you are. I can assure you that it works in Louisiana. We resolve about 90% of the cases. And that's not because there's some magic. You hear this all the time in mediation. Oh, bring the magic. There is no magic. It is simply slowing down, listening, considering, questioning without judgment. And that seems to be what most people want an option in doing. Not every case closes, and not every case closes that day. But I assure you that, as difficult as it may be in some situations, if you can invite the people element into that discussion in your jurisdictions, I think you'll see similar results. And this is just a few of the folks and all that have been very faithful and trusted us with helping them resolve their cases. Here's what the typical timeline looks like in most of these cases. You know, time is the great enemy for a number of reasons. It takes more money typically the longer the case goes on. I handle a lot of excess cases for some excess carriers I'm sure that maybe y'all would be familiar with. And you know, the worst day in the life of an excess carrier is the day they have to pay a claim. And so I end up with a lot of these cases that are very difficult to close. And of course, they're well past 36 months, and the amount of money that's been spent is often pretty significant. So it occurs to me, you know, as we have this conversation on what can we do to get on the front end of this time and expense curve. And we have a lot of tools that, again, I know that y'all employ and are very familiar with, and they're necessary tools. You know, in Louisiana, there's nurse case managers that attend physicians' appointments with injured workers and attorneys. There's vocational rehab. I don't know if y'all are in wage loss jurisdictions or not, but that's still a factor in Louisiana. And then you have the second medical opinion, which is almost always in conflict with the treating physician, which then triggers an independent medical examination. We have the right to petition the court for a third physician. And then there's the ever prevalent surveillance, and that's become more and more prevalent with technology, but some form of these tools are in almost every one of the cases that we mediate. What's interesting about these tools is that they are by and large tools to mitigate or posture a case for resolution. I've yet to be involved in any case where an injured worker walks in and says, you know what, I think that the employer's choice of physician is right and that I'm capable of going back to this level of work. Or I think that the court-appointed independent medical examination physician is correct and that I can return to work as well. What it does is it separates people, it drives them to the corners. And again, hear me clearly, I am not in any way suggesting those are not effective, but I think that the question must always be asked, will this next step bring me closer to resolution? And in some cases, you know, an SMO or an IME may not be the best step. So keeping that end in mind, as Stephen Covey would say, I think is critical to effectively closing cases. So in Louisiana, a lot of times people say, how can you close a case? I'll say, well, let me tell you where you don't want to do it in Louisiana. You don't want to do it in the court system. Louisiana transitioned from a district court system to an administrative system to manage their workers' comp cases in 1989. It was to eliminate local bias, but it was also to streamline the process. And it worked for a while. I will say this about the administrative process. As early as 1989, they had mandatory mediation in every workers' comp case. Unfortunately, it was not implemented very effectively, and it ended up being primarily a mechanism for service of the suit. But they did have that, and they still retain that. But there's some internal struggles with timeliness and qualification of the mediators. But in any event, the jurisdictions in Louisiana for employers and carriers is probably on the low end of favorable. So while a case can close in court, we can't get a final judgment, and oftentimes it simply extends the case. So again, mediation becomes an option like some of these other tools to circumvent a process that doesn't typically return very good results. And then here's one of my favorite. I remember a case several years ago. It was an unfortunate situation, but a 78-year-old gentleman had retired from his job, his career. And after spending several years at his home, his wife said, you know, one of two things has to change. You either have to get out of the house and go to work, or we're not going to be living under the same roof. And so he decided that he'd find himself a part-time job, which he did. And he actually went to work as a runner part-time for a law firm in Louisiana. And on one of his runs during the day, some inattentive driver blew through a stop sign and T-boned this man. And he ended up with a 4-level cervical fusion and a spinal cord injury that resulted in him becoming a quadriplegic at age 78. Some of y'all have handled those types of cases. You know that the medical is just, it's almost astronomical and exponential. Then you add into that factor the age of this gentleman. And I don't remember the exact numbers, but I do remember this. Because he was a part-time employee, his disability rate was somewhere around $150 a week. So that was not the expense in the case. It was the medical aspect of the case. So it rocks along for a couple of years, then it finds itself into our court to mediate. And of course, the excess carrier is involved in this one early on. And so we're going back and forth. The case does not resolve that day, but it breaks down over this. The individual at that time, and I could be off on the numbers a little bit, has about a 7-year life expectancy, and that's an age-related life expectancy based upon not only his pre-injury condition, but his post-injury condition as well. And the case locked up at around 5 years because carriers and the parties that were paying were simply not willing to extend that type of authority. And the injured worker, I think, was somewhere around 9 or 10 years or whatever. And that's a lot of money when you're dealing with that significant of an injury. But when we left, before we broke up, I asked the folks there for the carrier side and the employer side, I said, what is it that you're banking on? They said, well, we don't mean to be morbid about this. We just don't think the gentleman's going to live his life expectancy. Of course, it's in a private caucus. So I said, so really, we're basing the probability of settlement and what you are willing to pay on how long you think this gentleman's going to live. And they said, well, yeah, again, without being morbid. I said, no, understood, I got it. 4 years later, they called me back. Guess what? He'd lived 10 years and he still was going. And we settled the case. Again, that's a unique situation, but counting on somebody to expire is probably not the most proactive of ways to close a case. And then in Louisiana, again, this just rarely happens. Certainly we have no lost time claims, but for lost time claims, it seems like there's almost some type of residual disability. I just see so few cases with full duty releases. And if they do, then again, they don't end up in the litigation system or in the mediation world, but it's a pretty rare occurrence. And then in Louisiana, you do have an expiration for disability. Medical is for life, but it's 10 years in Louisiana. And the closer you get to 10 years, then what we begin to hear in this jurisdiction is, well, we think that they're incapable of ever returning to work because they've been out of the workforce for almost 10 years. And, you know, that's a hard burden in Louisiana. It was different in 1983, 1986, but they changed the law. But it's still what you begin to hear, and we end up with some of those cases. Had a case last week, you know, that had 78 weeks left on the 10 years. In the carrier's position, I was, well, only owe them 78 weeks. I said, well, the case isn't going to settle for 78. I'm not suggesting that you can't win that, but you're going to be 18 months in a poor jurisdiction and probably another 3 to 9 months in the Court of Appeal. And their lawyer was there, and I said, good lawyer, know him well and all, but I said, just let him go ahead and give you the budget for doing that. And let's see if we can use some of that to get there. And we were able to resolve the case. But my point is, waiting for something to get better is, in my experience, not a very good strategy. And so mediation again rises because it's focused on closure. It brings people to this decision point. They feel like they have their day, so to speak. And there's a lot to be said for that. I hear all the time how much this particular circumstance has changed somebody's lives. And what's really interesting to me is through the years, claimants counsel will say, look, he knows all that. He doesn't need to hear that. And I stop them and I listen to those stories because while it may not be particularly relevant in terms of determination of the exposure, it's highly important for that person to feel like they've been heard. And so mediation affords them that opportunity. So the next question is, where do you hold mediation? When we first started doing this, and we still do to some extent, you go to lawyers' offices. Now, all of us have had this experience too. When you make an appointment with your physician, you're usually escorted into a small room and then asked to hop up on a table that's too high for your legs to hit the ground and is also on crinkly white paper. And I understand that the physician environment requires a certain level of sterility and cleanliness that's maybe different than other business environments, but couldn't they make it a little bit more warm and friendly? And maybe your physician does that. I love my physician, but it's not a place that I'd like to hang out. And so we kind of reversed engineered this. We said, if people like Denny, who are used to working in diesel mechanic shops and physical environments, come to lawyers' offices where there are conference tables and glass and marble and leather and formality. Does this lower their level of anxiety? Does this help them make a decision? And we thought not. And so we created Claris Point, which probably many of you know that we have a large French heritage down here from the Acadians that came from Nova Scotia. And so Claris Point is sort of a mixture between Latin and French. It's the point where folks get an opportunity to see more clearly. In each of our mediation rooms has recliners, and it's got warm environments. We want people to be comfortable. We have an outdoor area. Louisiana this time of year is not a place you want to be outdoors, but there are certain times. We serve a catered meal every day, and we invite people into this space because we want to lower the level of anxiety. We want to give them time to process what's being asked of them and let them make an informed decision. So what's the skin in the game look like? I say it like this when I meet with people. I say, I have yet to meet anybody who's had a workers' compensation case who's looked heavenward and said, thank you for bringing workers' comp into my life. It is an absolute life disruptor. People who are making $1,200, $1,500 a week, in Louisiana, the maximum benefit right now is $743 a week. Their life is thrown into this chaos and Denny and Jen's situation. Their oldest daughter was getting ready to start LSU. Woohoo, go Tigers, we just brought home the natty. But in any event, they start this process and it's a shock right off the bat to them. So they're all looking for a way to sort of move out of this. The other thing that's very interesting to me is because we do a lot of work with self-insureds, Denny was a part of this organization for, I don't know, 15 or 20 years. This was his family outside of his small family, his genetic family. When he got hurt, he was told that he couldn't speak with any of his friends because he had a workers' compensation case. So not only is his life financially disrupted, but emotionally and relationally, he has this huge disruption as well. I don't think there's really anything in Louisiana that prevents that, probably not in your jurisdictions either. But I've tried to, when people have asked me from the employer side, I said, if you will treat people like you would like to be treated in that situation, you will find, I think, that they're more receptive. It doesn't play all the way across the system, and there's certainly some abuses, but the pendulum could move a little bit further, closer to treating people like you want to be treated. This last category you see on the screen is who's in the room, and I love this one because typically when I sit down in a mediation, you will have an attorney, you'll have an injured worker, and a lot of times they bring their wife, spouse, partner, somebody like that. But there's always somebody else in the room. And when I present, people say, what do you mean by that? And I said, let me give you an example. I said, less than 2 weeks ago, this happens all the time. Sitting with a couple, talking to them about their case, and the husband said, well, babe, what you think? And she says, well, I don't think it's very fair, but you do what you want. Well, that puts that husband in a very difficult situation because he is tired of it. He wants to get some closure to this, but he also knows that he's got to live with his partner, his spouse. And so he's got this difficulty. So I say, let's talk about this now. I mean, because whatever his wife's name was, if you're not satisfied, he's not going to be happy. Let's walk through this now. So we kind of walk through that process. But what I often hear is, well, my brother-in-law got this amount. I said, well, that's great. And they kind of look at me. I said, what's your brother-in-law's name? And none of them give me the name. And they said, why do you want to know his name? I said, because we're getting ready to call him. We can't help you unless we understand what your brother-in-law's case was like. And if somebody has had a similar experience and a similar outcome, then I'm all ears. I want to learn what that is. So give me his name and let's get his number and let's get him on the phone. Well, he don't want to be involved. Look, I can't tell you how many times I've done that, and I'm serious about it. I mean, we can't rely on information outside of that room, but I have yet to ever speak to a brother-in-law. So there's always another in the room. A similar situation is I will hear from people You know, Louisiana is divided basically north and south and all. North of I-10 is the Bible Belt, south of I-10 it's almost all Catholic. And so north of I-10, you have a lot of Baptist churches. And so I will hear people say, well, I need to talk to my pastor. I said, well, that's great. Get him on the phone. Well, no. And they always pause. And I'm more than willing to visit with them. I'm not going to grill them or anything. But again, we can't make effective decisions unless we have all parties at the table. And that's just a mechanism to keep them from delaying the decision that they probably want to make, but are not likely to make if we can't keep them in this mix in the mediation room. So the attorneys, look, when I started practicing, if you had a claim, or even with employers and insurance carriers, less so maybe on the employment and the carrier side, but if somebody had a claim, they made an appointment with that attorney and then went to their office. That almost never happens anymore in Louisiana. It does occasionally, but Louisiana has transitioned to more of what I call kind of a commoditized legal system, in the sense that there's so much advertising and these dominant firms are they're securing so many cases that there's literally not enough time for folks to have personal meetings like that. So they have this whole process of intake and meeting with people, which again is an evolution of efficiency, and it is effective in some sense. But here's my point. I was surprised when this started happening about 8 or 10 years ago. I'd go to a mediation because I've been doing this a long time. I know most of the lawyers, and I'd say, Frank or Kathy, where's your client? I don't know. I've never met him. And I was dumbfounded. I was like, oh my gosh, you're coming to a mediation and you've never met your client? And they were dead serious about that. Again, the business model of the firms that they work in really don't afford that opportunity in the same way that, say, in the early 80s or early 90s did. So I'm always trying to be aware of, look, this is relational. And if we can establish some level of trust and connection with this individual, whatever they decide we're going to be okay with, I tell everybody that walks through that door, we're going to honor your choice. It may not be the choice that I think is best for you, but you know what? Your tomorrow is your life, not mine. And I think that helps them understand that nobody's going to lean on them. What we're going to do is listen to them. And so when I walk in and a claimant's attorney has not met their client, I'm on first base. I mean, I got as much relational credibility with them as the plaintiff's lawyer, because it's the first time both of us had met them. And then the defense attorney, look, I did that for 21 years. I mean, they all want to deliver the result that their clients want, which is closure, and they've got this set of tools like this. But if you can help your defense counsel understand that a conversation early on is better than somebody getting entrenched in a rut that you have to pull them out of, I think you'll see better results in terms of your closure. And then I think most of y'all are familiar with, we know what the financial drivers are. You know, what's the reserve? Can we close it under reserve? What's the exposure? I don't know all those. I'm familiar with that. And people ask me all the time, do you want to know what my authority is? It's like, I don't want to know. And they look at me kind of funny and they said, why don't you want to know? I said, because I want to be freed from some target to do the very best that I can to bring this into a range. I got a pretty good idea what the case is worth. Now, if you don't want to pay that, that's fine. But I want to be freed from some boundary or limitation to just be present in a way that I think helps people make some type of decision. And this is the one thing I'd say about the claims handler or the adjuster is it really surprised me how mediation seems to be kind of a tool of last resort. And I think in these next few slides, you'll see that one of the things I suggest is invite this conversation earlier. If Denny goes and lawyers up, I can certainly work with that lawyer, but it's going to be a longer process because we're going to be in the system at that point in time. And so if you can have that conversation earlier, we reach out to people all the time in Louisiana, so can your defense counsel or whoever you're going to use to mediate your cases. And then I think this is the real key. I mean, look, we love our freedom in this country. You know, we want to feel like we have choice, and we really do. Sometimes we tell ourselves we don't have choices. We always have a choice, even if it feels like it's not the best choice. And so mediation is a process grounded in voluntary choice. This is sort of a checklist because people would ask me, when should I mediate? And they may be different in your jurisdiction, but look, the older the case is, the more difficult it is to resolve. Settlement requests, I love this one. I just got through responding to an email. Somebody said, could you reach out to the other side? We can't get them to respond, see if they're interested in settling. I do that all the time. And so I reached out, not in this case, but I have in the past. And sometimes I'm met with, this case isn't ready. Excuse me? This case isn't ready to mediate. The party who needs to make the decision is asking to come to the table. How do you know what's going on in their life? What do you mean? I said, there could be any host of number of things. They could have a payment that's due. They could be losing some asset. They could have a child going to college like Jen and Denny. I mean, you won't know until you get to mediation when somebody, a part of that decision-making process, is asking for an opportunity to resolve the case. You say yes. Every time you say yes. Now, you may not resolve the case, but you will always learn something in that process. 2 years, I mean, again, in Louisiana, when we see a case like that, it begins to get a little moldy. Some cases certainly go on much longer, but again, earlier than later having that conversation. As soon as you get plaintiff's counsel or treating physician involvement, begin that process of a discussion, because otherwise you're going to be spending between $5,000 and $9,000 on second medical opinions and IMEs. They're going to be possibly contrary to the treating physician. You're going to drag the case out between 9 and 12 more months, but you don't need those reports to have a discussion about what somebody's tomorrow could look like. I don't see a lot of this. I mean, and probably in y'all's world you don't either, but occasionally we get one of these cases where there's just been this cataclysmic change in handling, and nobody's done anything for a year, and it's just on autopilot. They're just not going to do it. They're not going to go back most of the time in this. Medicare, I love this one. If y'all were in person, I would call one of you out of the audience and I'd say, okay, look, efficiency and effectiveness, that's what we're going to think about. And I'd have you face the wall with your back to the audience, and I would be the claimant. I'd say, can you explain to me an annuitized MSA with a reversionary clause over the phone without looking at me? And of course, we've all had to do that to some degree. That is ultra difficult. And look, Denny knows more about a diesel engine than I will ever know, but he does not understand how an MSA works. I literally do not know how we expect people to understand the transition from workers' comp medical to Medicare by this process without some discussion face to face. But I know you've settled cases without it, but when I see a Medicare or an MSA issue, even if it's not an approved one, I'm like, get them to the table, man. You're going to spend time and money that you're not getting any value for, because they're not going to understand what that means. Litigation, I've already told you, in this state and all, from the employer or carrier side, it's expensive. And lawyers on the plaintiff side don't like to be in litigation here. That's not where they make their money. They make their money closing cases. So when we see active litigation, we get a lot of calls. Jurisdiction of venue, I've sort of covered that. We still have the second injury fund in Louisiana. It's not working very well, but anytime there's a potential second injury fund recovery, people ought to be on alert in this state and all, and get them to the table, because we can settle a case without second injury funds weighing in on the amount. If there's a pretty good indication, it'll be accepted. And then permanent total disability, which is lifetime benefits, that usually only comes about in quadriplegic cases or cases that run the expiration. You want to avoid that discussion, so get on the front end of that to mediate. And I want to watch my time because I think I'm getting kind of close here, but I'm going to see if I can sort of blow through this. Here's the piece that when I started doing this, I decided, and nobody was handling it this way, and you can find somebody to do it this way. I did not want people to be paying me to deliver a result based upon how long it took. What I wanted was them to feel like they got a value for what we delivered. Same way I built houses. So our pricing structure is, look, we resolve the case, it's 4,000. If we don't, it's 1,500. And we resolve about 90% of the cases. All of those items on the right side of the screen, they cost more than what the resolve mediation does. So it's really the only tool that you can have about a 90% chance of closing the case with only a $1,500 risk. That's Louisiana, may not work in your jurisdiction, but my suggestion is pay the people who bring you to the dance, don't pay them for how long they stay. Mitigation, this is typically what happens. You get an SMO, surveillance, IME, and you still don't have the case closed. This is what we see over and over again. And this is why we have 4 mediators now, not just me. Mediation, man, you still have all the time in the world. Go get an SMO and IME. This is just a graphic showing, you know, what else can you risk $1,500 for a 90% chance of closure in Louisiana.
Alan, you have plenty of time, just so you know. You're you still have 15 minutes, so you don't need to worry about that.
Okay. I wasn't sure if it was 40 minutes.
All right, no, you have 55 minutes. Let me ask a question real quick. We have somebody that wants to know what you negotiate. Are you negotiating permanent disability, or what is it that you're negotiating for?
So in Louisiana, we have a wage loss system. So typically we're negotiating resolution of medical, which you can close in Louisiana, and also the period or the amount of money that will be paid for future disability. So it's generally a combination of both of them. We do very few piecemeal mediations where we leave the medical open and resolve the disability portion.
Thank you.
Okay. So Diane, closer to 3:55, that's about what time I need to wrap up?
55.
55, okay.
Yeah,
cool.
but anytime between 55 and 4 is fine.
Yeah, no, I just, for some reason had in my mind that it was 45 minutes, but I'll have some time for questions if there are any more at the end.
Okay, great.
I spent 21 years in the arena of workers' compensation, primarily representing employers and insurers. Mediation is a tool that actually has as an objective the same objective that each side to a dispute in a workers' compensation case has, which is resolution. Mediation is about choice, to empower them to see options and ways for a tomorrow that's different from where they find themselves today. Time is literally money in a workers' compensation case. The longer it goes on, the more money and time is invested. And self-insured employers, unless they're an insurance company, have business objectives and goals outside of managing workers' compensation cases. The earlier that a self-insured can invite that process of discussion and mediation, they can reduce over time how much they spend toward the common objective of resolution. Prism has a shared partnership in the outcome that both parties seek. Prism's pricing reflects that. We have skin in the game, and it is results focused. There can be no better option than inviting people to both sides of the dispute early on to discuss what tomorrow might look like and achieve a result that works for both sides and leads to a better tomorrow.
So I want to come back to Denny's case because his is a really good example of why this process works, particularly with people who aren't represented. It certainly works with people who are represented as well. In fact, the vast majority of the cases, both parties are represented. But during the course of that mediation, Denny began to share with me a little bit about his life and his background. And I guess because I'm interested, I always sort of are interested in what people do for a living. And he was telling me about diesel engines. And again, I don't know much about diesel engines. I know a lot about building a house because I did that for a long period of time. But in that process, he mentioned to me that a lot of his work was on a metalworking lathe. And because I grew up in the building business and like wood, I have a wood turning lathe. And so Denny and I began to talk a little bit about the differences and what you could do on there. And one of my hobbies is turning wooden bowls. And so I had a bowl in one of the rooms that Denny was in, and I picked it up and I said, you know, Denny, I will tell you that a lot of folks that I sit with use this opportunity to sort of bridge their life from a difficult situation that they didn't choose to a tomorrow that works better for them. I can't define that for you, but there's never enough money in a workers' comp case for it to be a retirement case. It's not what it's meant to compensate. He had a very serious injury. He had a cauda equina injury, which basically is the nerves at the bottom of your spine kind of fan out into your lower extremities. And so he generally was kind of a paraplegic for a period of time, but he's learned to walk again. And I said, you may or may not be able ever to go back to doing what you were doing because it was really heavy, hard work. But I said, if you can free yourself from the burden of this uncertain tomorrow, and being idle at home is one of the hardest things for folks to do who have used to being productive and engaged in the workforce. I said, if you can find a path to that, I have no doubt that you and Jen will put together a life, even despite this hiccup in your life. And so on the way out, I had a block of wood that was eventually going to be a bowl. So I gave it to Denny. I said, you know, just give it a try at some point. And Denny settled his case. And after that, I wasn't involved. I wasn't the attorney that handled the settlement documents. But about 6 months later, Denny called me and he said, I want to let you know that I've gotten a wood lathe and I've been watching YouTube videos and now I too can turn bowls. And so this is not a bowl that Denny turned. I don't know if you can see this in the picture or not, but over the course of the next year and a half or so, Denny continued to send me pictures of turnings that he had made. And now he sells his turnings at some small craft shops in Southwest Louisiana. I'm sure that Denny doesn't make this type of living that he did before, but Denny has purpose, he has meaning, and now not only his first daughter, but his second daughter has graduated from college, which from an individual who nobody in his family except for him had ever graduated from high school, that's a pretty good result from a difficult situation. So like I said, I've shared with you the experience of mediation as it's been applied in Louisiana. And I just don't believe that people are that much different across different jurisdictions. We're all wired more similarly than we are different. We all want the same things for our lives and our families. Particularities may vary somewhat. And so what I would encourage you to do is find something that invites people into that discussion. It's certainly not, you know, in every case you can do it. And I understand the requirements of, you know, so many cases you have to handle and emails and stuff. And I'm in favor of that. But when you get a situation that you know is not going to be resolved through an email exchange or a text exchange or even a telephone call back and forth, find somebody that you trust to sit down with this person who's knowledgeable, who will listen to them without judgment, who will accept who and where they are and do their very best to say, we're going to honor your choice for a better tomorrow. And that would be my suggestion. So Diane, I really want to thank you and all the folks that I can't see, wish that I was in front of y'all, but this is a nice opportunity for me to share something that I'm very passionate about. And I think it's not only effective for people in the claims world and the employer and the insurance world, I think it's helpful for people in this system. And, you know, if I have any questions, I'd be glad to respond.
I don't see any other questions at this time, but I do want to thank you so much. You're a great speaker and the information that you shared is fantastic. I know that Colorado was a lot of fun to be at and just to be able to speak to that audience, and I really appreciate you coming and speaking to our audience today. I do want to let everybody know that today is the first webinar of our claims summer school. We will have 10 other webinars during the summer. Please go to the MacroPro website and check out all those classes. We're also doing a special series on COPS and claims. They're going to be mental health claims. And so that should be really interesting for those of you that handle officer related claims. Until the next time, I want to thank you very much for being part of Macro Pro and Friends. And again, Alan, thank you very much for sharing your expertise with us. Do look for your certificates in the mail today, and we will talk to you at the next Macro Pro and Friends. Bye-bye now.